And recent reform proposals for the UN have emphasized the links between collective security and respect for human rights, and underlined that the term security can no longer be confined to the security of states, but must be ultimately destined to protect individuals. Now, while acknowledging that sanctions remains an important tool, the 2005 World Summit Outcome document has also underscored that sanctions should be implemented in ways that balance effectiveness to achieve the desired result against the possible adverse consequences, including socio-economic and humanitarian consequences for populations and third states. And importantly, it has underlined the temporary nature of sanctions. So we've had numerous discussions within the Security Council and without, in other words, in regional courts, for example, over the fact that the Security Council sanctions are not unlimited, the Council is not above the law, and though courts have refrained from reviewing directly the sanctions on the grounds that it is not within their competence, regional courts such as the European Court of Human Rights and so on, there has nevertheless been a number of cases which have underlined the responsibility of member states in implementing collective sanctions for carrying out their obligations under human rights treaties. And the emphasis also has been on the due process for individuals. So the Council has responded to such pressure in a small measure, rather grudgingly, but it has. It's gone from comprehensive to targeted. It has instituted an ombudsperson for persons on the blacklists, which is not a judicial review, but is at least something, and has responded to calls of the World Summit Outcome document. And so we've had, of course, also the various bodies of the United Nations, such as the Economic and Social and Cultural Rights Committee, which has called on the permanent members to be responsible for the development. That's comment number 8. For the development, in adopting sanctions decisions, to be very conscious of their obligations under the Covenant on Economic, Social, and Cultural Rights. So we've had a lot of pressure from all kinds of organizations, specialized agencies, and regional courts, as well as the Human Rights Committee, for example, in the case of Sayadi. At the European level, you've had the cases of Qadi, Al-Jeddah, and so on and so forth. And the European Court of Human Rights in the Al-Jeddah case, turning to the limitations placed by the purposes of the Charter on Security Council decisions, said that the court, in interpreting its resolutions of the Council, must presume that the Council does not intend to impose any obligation on member states to breach fundamental principles of human rights. And in the event of any ambiguity, the court must choose the interpretation which is most in harmony with the requirements of the Convention. Here we're speaking of the European Convention, and which avoids any conflict of obligations. And in fact, a point that is important to underline is that while human rights in the Charter was part of the secondary obligations of the United Nations, collective security of peace was, of course, the primary. What has happened is that the human rights purposes have shifted in emphasis and become part of the whole collective security apparatus. The Council now imposes sanctions to protect human rights. So you cannot say that there is now a conflict between public order and respect for human rights law. One is an integral part of the other. So, the responsibility of member states has been underlined also in the draft articles, or the articles rather, on responsibility of international organizations, which recognizes a dual and even multiple attribution of conduct and shared responsibility between the the international organization and member states. So there are certain circumstances in which a state member of the Council may be responsible for the collective measures if, for example, it exercises direction and control of Council decisions, exercises coercion by playing a dominant role in the Council, for example, participation in the decision-making process when it rises to the level of overwhelming control. So, in short, I think that my conclusion now is that in the field of collective measures, we've had, in a sense, certain limitations which are going even beyond the constraints imposed by the ILC articles, or rather, one should debate those. I'm not saying that this is a hard and fast development, but I think this is worth pursuing as a study to see the comparison between the restraints on collective and unilateral measures. Just to conclude on a number of things which seem to me important, the problem in international law is that there is no compulsory dispute settlement measures for countermeasures. The ILC excluded, finally, a section which would have dealt with dispute settlement. Moreover, the collective measures cannot, the Security Council, the UN cannot be brought before any international instance, and of course before domestic instances, immunity applies. So we have a paradoxical situation in which states can impose coercive measures, but there is no way to counter them peacefully, in other words, through peaceful resolution. Of course, I'm not saying there is no totally, but at least there is no compulsory dispute settlement measures. But there have been some challenges, as I've said, before courts. Secondly, I think it's important to revisit some principles like those of non-intervention. I don't think it's enough to say, well, sanctions or countermeasures interfere with or violate non-intervention. Okay? They are allowable if they are in response to prior illegal acts. They are not allowable if they are used to change foreign policy or intervene in the sovereignty of states. Third reflection, there has to be a balancing act. We're talking really about public order, emergency situations, and human rights. And as you know, in all the treaties on human rights, there are special clauses for the ability to derogate in time of public emergency. But we don't have such clauses in general. Finally, or not quite finally, while non-forcible measures, whether unilateral or collective, continue to be a part, perhaps, and that's another debate, as an instrument for the achievement of certain important priorities of the international community, which, as you know, has seen a development in international public policy, a set of obligations fundamental to the international community as a whole. They are nevertheless not always compatible with such basic principles and with the rule of law. And finally, I just want to quote to you from Roberto Argo, which I think Dr. Pereira had mentioned, this development, where he says, in seeking a more structured organization or institutionalization of international society, we really should turn to a system which vests in international institutions the exclusive responsibility for determining the existence of a breach of an obligation which is of basic importance to the international community as a whole, and thereafter for deciding what measures should be taken. In other words, it's a big debate as to who should protect fundamental community interests. Is this a unilateral? Should this be left to unilateral measures by states, or should, in fact, we turn to a more institutionalized system? Thank you very much. I hope I didn't exceed my time very much. Thank you.
Thank you, Professor Dabas, for outlining the various developments in the field of sanctions, the move from comprehensive sanctions to targeted sanctions in the face of humanitarian concerns, and also describing for us the extent of countermeasures that can be lawfully taken. Now, next, I'll give the floor to Professor Gandhi. He will speak on sanctions and financial institutions. Dr. Gandhi is a former colleague of mine. He was legal advisor with Ministry of External Affairs. Now he's professor and executive director, Center for International Legal Studies, Jindal Global Law School. Dr. Gandhi, you have the floor, please.
Thank you. Madam President, Secretary General, Dr. Pereira, Professor Dabas, Rajesh Babu, Excellencies, ladies and gentlemen, Now, I must thank first to my all previous speakers, especially Professor Debas. She made it clear that US sanction can be a framework for analysis. In my paper, I am going to do that only, because mine is focusing on the implications of unilateral and secondary sanction on financial institutions. US sanction, sanctioned by EU, and sanctioned by United Kingdom. Without referring to that, one cannot cover this field. I'll try to do justice for that. Since the days of Pericles of Athens, political states have deployed economic sanction as a weapon of international diplomacy to bring change in the attitude of sanctioned state. But we are going to deal with now the secondary sanction. It is not unilateral primary sanction. We know that it is United States which imposes that kind of secondary sanction every now and then. Jeffrey Mayer, in his research paper on secondary sanctions, enumerates that the United States today has unilateral sanctions programs relating to many countries and regions, including the Balkans, Belarus, Cuba, the Congo, Iran, Iraq, Cote d'Ivoire, Myanmar, North Korea, the Sudan, Syria, and Zimbabwe. The broadest of its programs involve general embargoes on trade and financial transactions with long-standing hostile regimes such as Cuba, North Korea, Iran, and Syria. Other sanctions measures focus more narrowly on penalizing the leadership and close associates of enemy regimes, as well as hundreds of designated terrorists, drug trafficking, and weapons proliferating persons and entities. UK and EU have sanction programs of their own. Most of the economic sanction regimes deployed by the US are primary sanctions only, which restrict its own companies and citizens or other people who are in the United States from doing business with certain specific countries, terrorist groups, or other countries against them. Already international sanctions are in place. Secondary sanctions, such as secondary trade boycotts and foreign company divestment, involve additional economic restrictions designed to inhibit non-US citizens and companies abroad from doing business with the target of primary US sanctions. Secondary sanctions have proven highly controversial because they are illegally extraterritorial in purpose and effect. There have been resistance to sanctions to start with. When US imposed unilateral sanctions on Cuba, Iran, and Libya, their major trading partners, EU, were hit by secondary sanctions. They oppose the sanction and regard them extraterritorial application of US sanction, and they regard this as unacceptable attempt to expand US jurisdiction. Despite sanctions were in place, EU reaffirmed its commitment to the achievement to the greatest extent possible of the objective of the free movement of capital and to the lowering of trade barriers. EU viewed the US imposition of secondary sanction as a departure from the free trade principles long advocated by US itself. Another case of Europe's resistance for unilateral secondary sanction was the Siberian pipelines case. This happened in 1982 when the United States sought to impede the construction of a pipeline from former communist Soviet Union to Western Europe. It not only prohibited US companies from providing parts and services